Hello, and welcome to our podcast. I'm Aryan Kamyab. Today, I'm going to speak to you about the accident insurance system in Ontario. The significance of car insurance is based on the fact that every year there are thousands upon thousands of accidents in Ontario. For instance, in 2023, there were more than 26,000 car accidents in the province of Ontario. Each one of these accidents contains injuries and contains property damage. I should highlight and mention that the 26,000 plus number of accidents that I'm referring to are accidents where somebody has sustained an injury. There are more minor fender benders, if we can call them that, where there is no injury, but 26,000 plus in 2023 alone resulted in injuries. So whenever there is an accident, there are two things that we have to look at. One, there is property damage, which is what we refer to when we're talking about the damage to the vehicles involved. And two, there are possible personal injuries. Now, as a personal injury lawyer, we assist clients in handling, navigating, and pushing forward their personal injury claims. In addition to that, if they have issues with their property damage claim, we could be of assistance as well. The property damage system in Ontario, under the auto insurance rules, are actually quite simple. In Ontario, your insurance company, your car insurance company, is the company that has to compensate you and fix your vehicle when there is a crash. That it doesn't matter whether or not you're at fault for the car accident. This is an interesting rule that's been created for a very long time in Ontario, and it always confuses consumers. Clients always tell us, I don't understand why my car insurance company has to pay for the repairs to my car or has to pay for the cost of writing off my car if another person was at fault and negligent and caused the accident. Well, that's just how the rules have been set up in Ontario. And in fact, it has a lot of advantages for consumers. For instance, if there is an accident, God forbid, and there are injuries and two cars are damaged, as the innocent party, as the party who's been hit by an at-fault driver, you don't have to worry about whether or not the other person has insurance. Your own insurance company is going to take care of the repairs to your vehicle, your rental vehicle for a specific number of days, and things of that nature, or the cost of writing off your vehicle. Your car insurance company then can, in certain circumstances, recover the amount that they're paying for the repairs or writing off of your vehicle from the at-fault driver's insurance company. However, you don't deal with anybody else other than your own insurance. And I think that has a lot of benefits for consumers. So let's talk about an accident example. Two cars are involved in an accident. Driver one is at fault. Driver two is injured, and their car is a total wreck. The airbags have deployed, and just by looking at the pictures, you know that this car is beyond repair. It must be written off. One thing I can explain about writing off a vehicle, what is the rule? How does it work? The rules say that if an insurance company looks at a vehicle and determines that the cost of repairing that vehicle is 70% of the value of the car on the date of the accident. So how much was the price of the car on the date of the accident based on its mileage, its model, its year, and various other factors. Once they determine the value of the car on the date of the accident, that's the amount that they're prepared to pay in order to settle the claim. But what if the cost of repairs exceeds 70% of the value of the car? So if your car is worth $10,000 and the insurance company looks at it and says, it's going to cost us $4,000 to fix it, the rules say that they should fix it. However, if your car is worth $10,000 on the date of the accident and the damage on your vehicle is going to take $8,000 or $9,000 to fix it, the cost of fixing your vehicle is more than 70% of its value. Therefore, the insurance company is not going to fix it. They're going to write off the car. In exchange for writing off the car, they're going to pay you the actual value of the car on the date of the accident. In this example that I just used, the value of the car was $10,000. So they're going to pay you $10,000. And one more thing they're going to get from you is they're going to take your wrecked car from you because they can sell it for scrap metal and for other value. So that's what happens when there's an accident and you're not at fault. And then your insurance company has to determine whether to fix the car, repair it, or to write it off and give you a check. So what would happen to the at-fault driver in this example that I just gave? The at-fault driver's insurance company is also going to either repair their vehicle or they're going to write off their vehicle. The same sort of process that happens with the innocent party happens with the at-fault party. Both individuals only deal with their own insurance company. But there's a difference between the options available to the at-fault driver versus the not-at-fault driver. The not-at-fault driver, the innocent party, is able to also start a lawsuit or what we call an action against an at-fault driver. They can sue them for pain and suffering, lost income and lost economic opportunities, let's call it, housekeeping expenses, certain medical expenses, and legal fees, court costs, and there's even something we call prejudgment interest. So there's even interest that we can charge in these lawsuits on the amount that our client deserves to recover as a result of the injuries. That is what we call a tort lawsuit. Now, to forego the technical terms, essentially, what it means is the innocent party has a right of claim or lawsuit against the at-fault party. I should mention something about suing the at-fault driver, because people, when they hear the word sue or the phrase sue, it's intimidating. It causes concerns for them. And they're like, okay, I don't want to, inflict harm or hardship on somebody who made a mistake in an accident. A lot of people feel that way. And you don't have to worry about that individual who was at fault in the accident. They're not going to be personally impacted in the sense that their insurance is going to step in and defend them. And their insurance is going to pay the damages. And typically, drivers in Ontario have a $1 million liability policy, meaning if you get sued for negligence in a car accident and causing somebody harm, you have up to $1 million of coverage for any liability. That's sufficient to cover 99.999% of accidents. And so when you sue someone for their mistake in an accident, you're not going after them personally in the sense that there's an insurance company that's going to defend the lawsuit. And the insurance company is going to determine how much to pay. And the person who's getting sued doesn't have to pay legal fees. They don't have to pay any sort of damages or settlement out of pocket if it's within the policy limits. Therefore, it's not going to be something that causes a huge adverse impact in the at-fault driver's life. When people get into an accident, a lot of times they just repair their car and move on, because they don't want the notion of having to sue someone. They don't want to harm the at-fault driver. We see this all the time. And a lot of times they also don't know the process, the procedures, and they don't know their rights. They don't know what benefits exist for them in the insurance system when they're at fault, when they're not at fault. They're not aware of these things. And I could say that that is very detrimental to consumers across Ontario. Lack of knowledge and lack of knowing what your rights are will cost you. because you have to keep in mind the premium that you pay every month for your car insurance is paying for a host of benefits. And if you only end up using a fraction of those benefits, you've actually received less services from your insurance company that you were entitled to and that you actually paid for. So people shouldn't forego their rights because they worry about what's going to happen to the other driver. As I've explained, the other driver has insurance and they're going to be okay. Also, they shouldn't forego their rights in getting benefits from their own insurance company. When people come to us months or sometimes years after the accident with problems that persist, psychological problems, physical problems, and they want us to take action, a lot of times we have to be the bearer of bad news. We have to tell them, because the claim process wasn't started when the rules stated they should be started, it is now a lot of times impossible to start a claims process. Nothing's been documented, the claim has not been commenced, and you're behind the ball at this point. And unfortunately, you are now going to get less benefits, or you're not going to receive the benefits that you could have if you had pursued the claim from the outset. And now let me tell you a story. A client came to us 9, maybe 10 months after their accident had occurred, and they had done nothing. They only had their car repaired, but they had not started an accident benefits claim for their injuries. The reason they sought our help was because our client was having debilitating back pain. They had some disc issues in their lower spine, and it was causing a lot of pain in the back. It is also a lot of shooting pain into the legs. It was preventing our client from working. Our client was once a successful real estate agent. However, as a result of this accident, she really struggled with her work on a daily basis. So we looked at the circumstances and realized we are way past the deadline to start a claim. By law, you have 7 days to inform your insurance company or your insurance broker that you've been involved in an accident. And by law, once you inform them and you inform them that you've been injured, they send you a package. That package, you have 30 days from the date that it's sent to you to fill it out and submit it. Our client had not done any of these things. And a lot of times, insurance companies can use this against the claimant to deny their claim. However, we were quite persistent. We appreciated how much pain and suffering our client was going through. So we explained the reason for the delay. Insurance companies have the ability to accept the explanation, or they can challenge it. In our case, they initially wanted to challenge the explanation. However, ultimately, they accepted it and the claim started. The explanation was that our client had some injuries to her lower back over 20 years ago. Those injuries had healed. Now, this accident re-triggered that injury and the pain had started again. However, it was a gradual decline in her lumbar spine. And this gradual decline caused the delay in reporting the accident for accident benefits. It caused the delay in starting the benefits claim. It took months for her back condition to get to a point where it was so bad that it prevented her from working. Luckily, the insurance company saw that we're very serious and that our client is determined, with our help, to get the benefits that they deserve. The insurance company ultimately accepted the claim. Not only did our client get a significant amount of treatment that helped her a lot in her daily activities and just living every day, but our client also, after receiving a significant amount of treatment, tens of thousands of dollars worth of treatment from the insurance company, was able to recover a total of $240,000 at the very end of the claim in the form of a cash settlement. It was a significant change in the trajectory of the claim and how things were going for her. She went from a position where the law technically said you have not started a claim on time, you're out of time, you cannot do it. She went from that position to a position of getting the treatment that she needed and getting a significant settlement that helped compensate her for her losses, for her pain and suffering, and for the future medical care that she'll need. The moral of the story is not to delay. We don't want to be in a position where we have to fight tooth and nail with the insurance company to explain why there was a delay. However, if there is a delay, there may still be a chance if the right approach is taken by your lawyer. If you've been in an accident, make sure you know your rights. Call us for a free consultation. We're here to help. And we'll see you next episode.